Why can't Parliament simply pass new laws to fix immigration? It's tempting to think national law trumps all, but the reality is more complex and full of legal tripwires. The UK is legally bound by the European Convention on Human Rights, the Refugee Convention, and the Anti-Torture Treaty, meaning that, for instance, non-refoulement is non-negotiable under multiple agreements. Consider the 2021 case where the Home Office tried to deport Afghan nationals, but courts blocked removals, citing a real risk of torture based on up-to-date evidence from conflict zones. Flights were grounded, legal costs soared, and no removals occurred. Some might argue treaties are just words, or that you can sidestep responsibility by shifting people to third countries. But courts consistently rule. The UK remains responsible for each individual's safety, regardless of creative outsourcing. Looking forward, unless the UK exits these treaties entirely, a process with huge diplomatic and reputational costs, the courts will keep enforcing these rules, and legal workarounds will fail. Can mass detention and removal without appeals really speed up immigration control? It sounds bold on paper, but the legal checks are much tighter than most realize. Statistically, over 60% of long-term immigration detainees are ultimately released, not deported, due to legal barriers or lack of removal flights, according to Home Office data. Take the 2019 case of a family detained for months despite their child's best interests being at stake. Courts intervened, ordered their release, and the government faced damages for unlawful detention. Critics might say, why not just remove appeal rights? But both UK and European law require effective remedies. When the government tried to restrict appeals, judges often found alternative routes, meaning delays, costs, and reversals. The lesson? Without strict, individualized assessments and real legal remedies, mass detention and blanket appeal bans will trigger litigation and compensation, not faster removals. Is transferring asylum seekers to countries like Rwanda or distant territories a shortcut to control migration? Many think so, but the legal and practical barriers are formidable. After the UK Supreme Court's 2023 judgment, no transfers to Rwanda proceeded, as the court ruled that Rwanda lacked proven safeguards against onward removal to unsafe countries. For example, the Australia Nauru model was cited as inspiration, but it led to years of litigation, high costs, and was eventually scaled back after international criticism and domestic court orders. One counterpoint is, can't we just use overseas territories like Ascension Island? Yet, UK law still applies, and courts have flagged issues with access to justice, medical care, and due process, making such schemes legally vulnerable and politically fraught. Going forward, any third country plan will demand ironclad, monitored safeguards and still face challenge in every individual case, meaning high costs and low certainty for removal targets. Will tougher data sharing, new crimes, and sea pushbacks finally solve the removals challenge? It's a compelling idea, but runs into practical and legal barriers at every turn. The Information Commissioner's Office has flagged that automatic NHS Home Office data sharing risks violating UK data protection law and could deter vulnerable people from seeking medical care. Recall the 2018 NHS Home Office memorandum. It was scrapped after legal challenges, negative health outcomes, and public backlash forced a U-turn and policy overhaul. You might hear, if people break the law, new criminal penalties will deter them. In reality, most prosecutions burden courts and prisons, while refugee protections still shield many from removal and backlogs only increase. Looking ahead, expect that aggressive enforcement will hit legal walls, rack up costs, and do little to actually increase removals, as every step is challenged in court and watched by regulators. What's the real price of pursuing mass detention and hardline removals despite legal barriers? It's not just financial, it's years of gridlock that few see coming. The Home Office faces tens of millions in annual costs for unused detention beds, compensation for unlawful detention, and legal fees without corresponding increases in actual removals. Look at the failed fast-track system of the 2010s. Despite big investments in rapid removals, legal challenges led to repeated court defeats, millions in damages, and eventual policy reversal. Skeptics might say, is there any alternative that actually works? The evidence points to faster, fairer individual decisions, early legal advice, and community-based case management as more effective and affordable. Ultimately, investing in lawful, targeted reforms is the only path that reduces costs, delivers results, and stands up to scrutiny instead of fueling endless, expensive stalemates.